At this time, I'll be the chair, and the chair lays out HB 2581. Chair offers up a committee substitute to HB 2581, and the chair recognizes Chairman Dutton to explain the bill.
Thank you, Mr. Chairman. Members, this bill is a bill that came to me by way of an interested party about child care expenses for a mother, particularly, who is getting child support but needs to go to work or go to school and incurs child care expenses. Child care expenses in the original version were treated almost exactly the same as medical care or dental care was, but in the committee substitute, we've taken that out. We've taken it out and made it a separate claim by itself so that it's not treated the same way, because child care at some point is going to end because the children may go on to school somewhere, and so you would need to do it. But that's essentially what this does. It just directs that the court could order expenses for child care expenses. It doesn't require that the payment be made to a Title 40 agency, a local registry, or a state disbursement unit. It can be made directly to the child care facility.
All right. Members, are there any questions? All right. At this time, the chair calls Steve Bresnen.
Thank you, Mr. Chairman. My name is Steve Bresnen. I'm here on behalf of the Texas Family Law Foundation in favor of the bill. Appreciate you bringing it under current law in the child support statute, section 154.123B6. The court is allowed to deviate from the standard guidelines and take into account expenses incurred by either party to maintain gainful employment. In this bill, it requires the court to allocate child care expenses between the parties if one of the parties is, if it's necessary to maintain gainful employment or to get some kind of education or vocational training leading to vocational. It doesn't just shift all of the costs to one party, but it allocates them based on the party's individual circumstances. In your packet or your handouts, I've given you two very useful things that were educational to me. One of them is Texas has the seventh highest child care expenses on average. It takes people 20.4% of their income to cover child care. And right now, the child support statute is virtually silent on that. And there's a second page that'll give you a lot of interesting data about how many families there are with kids in the preschool ages where child care would be most needed, and then older ages where maybe after school care would be needed. And Mr. Chairman, I'm happy to answer any questions, and thanks for bringing the bill.
All right. Thank you, Mr. President. Members, any questions? No? Thank you very much. At this time, the chair calls Charles Suis.
Thank you all for your service.
I know I got that one right. I remember that.
Thank you, Representative Lujan. Lujan?
Yes, sir.
Chair, my name is Charles Stephen Suis. I'm testifying against 2581, and I represent myself and my family. This adds another slot of expense to whoever ends up being the non-custodial parent, and that really needs to not happen until it has to be conditional upon exhausting the possibility for shared parenting. Why should I pay for my children to go to childcare when I work from home and I'm available to be there for my children? So, thank you very much. I can take questions.
All right. Members, any questions? If not, thank you very much. Mr. Suis? At this time, the chair calls David Green.
My name is David Green. I represent myself, and I am against the bill.
Okay.
I agree childcare expenses during school hours should be split between parents, separated. However, it should not be done as an addition to the current guidelines without modifying the current guidelines. The current guidelines already had the cost of childcare in mind when they were developed, so this bill uses the phrase according to the party circumstances. And excuse me, I have not read the committee substitute, which I believe is ambiguous, and I don't believe it considers how much current child support is already paid. I think Mr. Bresnen had mentioned child care takes up about 24% of a household's income. Well, the starting guideline support is 20%, so from the non-custodial to the custodial, so take half of that. That covers the non-custodial parent's portion of child care. This bill is also unclear as to how the child's evolving child care needs are to be allocated. Do parents have to go back to court once a child moves from daycare to elementary school to then argue over after-school child care? Then go back again to argue when that child care should end? I don't see how a judge makes an order based on this language that will last and not require multiple modifications later. Let's take the example of one parent who is a teacher, so they have the summers off, and the other parent does not. Does the parent who is the teacher need to pay for the other parents, half of the other parents' summertime childcare needs? HB 2581, while good intentioned, is going to make a bad system worse. The way to solve the burden of childcare expenses is simple. Give fit, willing, and able non-custodial parents the presumption of equal parenting time. That way, each parent can be responsible for their own child care expenses during their days. For over a decade, we have not been able to get a timely hearing for floor vote, and if equal time is not appropriate, the bill will still have language added to consider the child support that's already paid. Thank you for your time and allowing me to speak.
All right. Thank you, Mr. Green. Members, any questions? If not, thank you for your testimony, Mr. Green. This time the chair calls Delilah Crosby.
My name is Delilah Crosby. I'm testifying on my own behalf as an advocate for fathers, and I am against this bill. Once again, this bill is going to affect fathers. They are the majority of non-custodial parents in Texas. There's multiple issues with this. If the language could be changed, or there could be set guidelines as to determine the need for childcare, then I may be in favor of it, but at this time it does not provide guidelines to prove that a mother may need childcare. For example, Flamingo Island Daycare, North Texas, is not willing to accept payments from two different parents, and father is not willing to pay mother for in cash as she prefers so that she can pay this daycare, and then they would not provide a receipt to prove that, which would be giving her the opportunity to take him back to court so that he has to now argue that he did pay it and he could face a penalty in court. Not only that, he is a Native American and his family believes in tribal community, so he has grandmothers, aunts, sisters, and everybody willing to watch this child, and mother will not agree to that. So if there's an option for that takes out the cost for both parents, that should be the primary guidelines, as we do encourage family engagement, not just fathers. So with that, I'm going to be against this bill in hopes that language will change to create more clear guidelines on how we even determine that mother truly needs the daycare costs paid for.
Thank you, Ms. Crosby. Members, any questions? If not, thank you for your testimony. Appreciate it. This time, Chair calls Jeffrey Morgan.
Thank you, Chair Lujan. I appreciate being called up again. Jeffrey Morgan. I am on this bill. I have some concerns about it. I'm testifying only on my own behalf. The first thing, I think it's kind of been alluded to. I think that if there is a situation where there are two parents, that this bill here should say something about the right of first refusal. And I know because, as Charles mentioned and others may also mention, if they're available to provide child care, why should they have to pay for something that they are willing to provide? And we've talked about extended family and stuff like that too. There's oftentimes family that will be involved with that as well. When it comes down to the courts actually making the determination, I've seen personally, like I said, I've been in probably 200 different cases over the last couple of years, either virtually, in person, Zoom. And I've seen types of judges. I've seen a few that I think are really good, but I've also seen the white knight judges, and I've seen the feminist judges. And then I've seen some that maybe have been the other way too. So I don't really trust the judge's judgment on this. The court all of a sudden gets to act as if the court is the super parent or something like that. I think that can be a disaster at times. But the big thing is for me, and the other thing is that we'll say a mother for this instance, she gets her new job. Does that readjust the child support then? Because if she's making more money, from my perspective, it only makes real sense if you have an income shared model versus what we have right now, the single payer model. And I know that Chairman Dutton has had a bill regarding that. So some of these things with the Texas Workforce Commission, do they offer any type of child care? If you're going back for training, some of the schools actually provide child care for the people that are going back for a degree. And then is there a limitation on this? Is it going to be a 6-month thing that the person gets a certificate and then maybe wants to go back for another year or 2 years? This could be a long-term thing. So I think that there are situations that would make this not fair, not equitable. I am testifying on it. I'm not going to be with my friends who testify against it, though I lean that direction. There are some issues that I think need to be addressed and clarified. Thank you. Any questions?
Mr. Morgan, thank you so much. Members, any questions? If not, thank you for your testimony. Appreciate it. Chair calls up Brandon Johnson.
Brandon Johnson, against the bill, testifying on behalf of myself. And I also want to thank you, Representative Lujan, for your undivided attention today. Not that we haven't gotten it from everybody, and Mr. Cook, you as well, and Ms. Lopez, and everybody else when they don't drift off. It's been a long day, so I understand. This bill needs to be amended so that only if equal custody was waived by the father, then it would be, I think it would be justified. If the father said, hey, I don't want to have equal custody, I can't, say he's unfit, he's unwilling, or he's unable, then I think it's justified. If the father has, and then also on this bill, if the father had a first right of refusal to keep the child instead of putting the child in the daycare, even if it's not on his designated time within a standard, expanded, or equal custody order, if he had that first right of refusal and he said, I don't want to take care of the kid, then fine, make him pay for the child care. That would be fair. But if equal parenting for fit, willing, and able parents was passed or amended into this bill somehow, it will promote parents working the issues of child care among most of every other issue out amongst themselves without state interference. Thank you.
Thank you, Mr. Johnson. Any questions, members? If not, the chair calls Taran Champagne.
My name is Taran Champagne. I represent myself, and I am opposed to this bill. Kind of looking at this bill, we're trying to add additional costs for childcare expenses. It's my understanding that that's kind of what child support already is there for. If we kind of look at what the state of Texas does for foster families who are raising children 24, well, not exactly 24 hours a day, but the idea is they're the responsibility of the parents 24 hours a day. The state of Texas reimburses them at $27.07 per day. If child support is being ordered for this child, should this not be considered what is needed, the basic needs for the child being met? While I understand we want the best for our children, we should all be kind of held to the same standard. Just because somebody makes more doesn't mean the child needs more. That's a discretionary decision by the parents. If that $27.07 is not enough, then our foster care system is failing children. I think we've had plenty of testimony on that. I would say if a parent needs time to get that education or find stable employment, perhaps the child should be in the care of the other parent who already has that stable employment. Honestly, if parents had that equal custody, there would be more time for one parent to pursue gainful employment or additional education. Texas's child support system is already heavily broken as it is. It's one of 3 states, the other 2 being Mississippi and New York, that does not look at either both parents' income or the time the children spend with the parent. This leaves one parent at kind of a severe disadvantage. Once again, in many cases, this is through no fault of their own. That's just kind of how the system shakes out. Before we kind of continue looking at this bill as it is, I think we should really consider overhauling the child support system rather than trying to put Band-Aids. As you know, my Representative Talrico said, we don't want to put Band-Aids on things. We want a real fix for our children of Texas. And that's my testimony.
Thank you, Mr. Champagne. Anybody have any questions, members? If not, thank you for your testimony.
Thank you very much.
All right, that's all of the folks that's registered. Is there anyone else who would like to testify on, for, or against the bill? If not, if there's not anybody else, I'm going to recognize Chairman Dutton to close on HB 2581.
Thank you, Mr. Chairman and members. It's somewhat predictable who was going to be for and against this bill, so I close.
All right.
I got a question.
Yeah, I'm sorry. Yes, sir. Go ahead.
Thank you, Chairman. Chairman, the question I had in reading the bill, I mean, I don't think that this bill would preclude, you know, we keep talking about fathers being the non-custodial parent. The way I read this bill, it looks like a father could ask the mother to pay his child care expenses on his time as well, correct?
Absolutely. I was going to suggest that my reading of the bill was that way too, but apparently I don't think some people read the bill. I certainly didn't see the committee substitute.
Yeah. Okay, great. Thank you.
Thank you, Rep. Cook. Anybody else have questions?
I close, Mr. Chairman.
All right. The committee substitute is withdrawn, and if there is no objection, HB 2581 will be left pending.